Calling the case on this afternoon's docket. It's now 1:30 p.m. Case number 116530, State of Kansas v. Alcina M. Dawson.
May it please the court, I'm Roger Falk. I'm here today on behalf of the petitioner appellant Alcina M. Dawson. First of all, I want to apologize to the court for yesterday. I can tell this court that between December 20th and today's date, I have spent between 50 and 60 days flat on my back. I have had pneumonia and been diagnosed with COPD. I also have a growth in my right lung that I'm being treated for. And I left the firm that I was with on January 25th, and I just did not catch the notice, and I apologize to the court for that. It's no excuse, but I want the court to know that.
But you're here today, the day after the argument that was scheduled, prepared to proceed.
I am prepared to proceed. My voice may go in and out on me, Your Honor, but I'm prepared to go forward, yes.
All right, and just so I'm clear, the notice of yesterday's proceeding was sent to you, but you did not take note of it, or what exactly happened?
Apparently, Your Honor, it was sent to my old address, 500 North Main Street, because I didn't get my address changed with the clerk of the court until like the 14th or 15th, and the notice went out on the 4th, and I did not catch it on the e-flex notices. Eventually it did. Yesterday, when I started digging through some things, I found where it had been forwarded to me in a large package of mail that had gone to the old office that was forwarded to me. And I've been appearing before this court for over 40 years, and I've never had that happen before, and I apologize to the court.
All right. While you're here, I did want to thank opposing counsel for his willingness to postpone yesterday's oral arguments. It would have been within his privilege to say, no, I want to proceed yesterday without you. But he graciously said, let's hold it over, so give Mr. Falk a chance to attend. So thank you, Mr. Gillette, for that.
And he and the clerk were both kind enough to call me during a recess and spoke with me, and I've known Mr. Gillette for years. He and I have practiced opposite one another.
The phone call you're referring to was yesterday during our recess. Right?
Yesterday's recess.
All right. Thank you, counsel.
A brief background on this case. Alcina M. Dawson was convicted in 1997 of rape and sentenced to 727 months, I believe it was. Part of the reason for that was he was found to be a severity, or not a severity level, criminal history category of B. The criminal history category B was derived by having 3 misdemeanor person convictions that aggregated into 1-person felony, and a burglary conviction from back in the 90s. I'm not sure, I can't tell you the exact year right now, but in any event, the statute in effect at that time did not have dwelling as a statutory element like our current statute does to distinguish a burglary from being a person versus a non-person felony, much like the situation this court addressed in Dickey 1 and 2. Okay. And this case is very similar to Dickey 1 and 2.
Mr. Falk?
Yes, Your Honor.
A factual distinction. I believe, and I want you to confirm, is that Mr. Dawson's sentence was affirmed on direct appeal and the mandate issued before the June 26, 2000 opinion in Apprendi, correct?
March of 2000 was when his sentence became final, and 30 days after that would have made it April. So there was a
So
60-day gap in there.
you concede that his sentence was final before Apprendi became effective, before it was filed.
Before it was decided. Yes, Your Honor, I agree. And I recognize that's a distinction between Dickey 1 and Dickey 2, that Mr. Dickey was sentenced sometime after Apprendi was decided, and after DeCamps, and that line of cases. Now, and I think part of the reason we're here is because we've ended up with two different lines coming out of the Court of Appeals. One is represented by the Tower case, T-A-U-R-E-R, cited in my brief, where the Court of Appeals essentially held, under similar circumstances, that the defendant was not entitled to relief. And then you've got McAllister and Dickey, which have found that they were entitled to relief. Now, the legislature, in response to this, enacted a statute, and I believe that was the subject of Justice Biles, or perhaps it was Justice Rosen's question on the first case this morning. Does that legislative change, well, first of all, the first hurdle is this an illegal sentence? In this particular case, since it is a situation where he may have been placed in the wrong criminal history category, I believe that the holding in Dickey is that where that is your situation, where you're in the wrong criminal history category, that is an illegal sentence, subject to modification at any time under the statute. Now, excuse me, earlier today, I believe it was Judge Johnson in the first case who asked the question, and I addressed this in my brief. Your Honor asked the question, when the legislature made the hard 50 fix, they didn't have any trouble telling us that that was going to be applied retroactively. However, when they amended the statute in this particular situation, they did not do that. Now, I realize that some of the questions being posed earlier today were, isn't it pretty clear that the legislature was being asked to fix the situation where everybody was coming in under Apprendi, Dickey, and fix this situation. But in this particular case, I go through a step-by-step analysis of why this is a substantive change in the law and not merely a procedural change in the law. Okay? Anything that affects the sentencing, a sentence that someone can receive, is a substantive change in the law. Therefore, I argue in my brief that the law which ought to be applied is the law which was in effect at the time of the commission of the crime and at the time that the defendant was sentenced, not this later enactment by the Kansas legislature in, I believe it was 16 or 17, they modified the statute. Excuse me. In any event, we get into a question here of should this statute be given retroactive application, or in the alternative, is my client time barred because his sentence became final before Apprendi was ever decided in this case? What was Apprendi all about? Apprendi was about the right to a trial by jury, something that is guaranteed constitutionally. And the Supreme Court held that in Apprendi that when it comes to things that can cause a sentence to go up, that those are things that need to be decided by a jury unless it is a prior conviction. That's the basic nutshell of Apprendi. And, we saw that get expanded in cases like Descamps and, I'm sorry, I can't think of the Hard 50 case, Aileen. We saw that expanded in those cases, but it was still always going back to what was it that was guaranteed by the Constitution. It was the right to a trial by jury, and the right to a trial by jury included the right to have a jury determine those sorts of issues. Now, in this particular case, what we have is a statute which did not require a dwelling. Under the old 213715, it did not require any sort of a showing excuse me, that the burglary was of a dwelling. So the court has to go back in and fill in the blanks in order to come up with whether or not, what type of a burglary this is. And I don't think that that's a determination the court can make. Now, I'm sure, and I know the state has argued that that wasn't the law back in 1997 when Mr. Dawson was originally sentenced. It didn't become the law until 2000 when Apprendi was decided. And I realized that his original conviction and sentence was affirmed in March of 2000, and Apprendi was decided in, I believe, May or June of 2000. So there's a 60-day gap in there. So even if you go 30 days for the mandate, it was still final judgment, except it was still within that 90-day window when one can seek to file a petition for certiorari with the United States Supreme Court. Now, in this particular case, no such petition was filed. But one could have been filed, especially in light of the decision. It's my understanding you have 90 days from the date a decision is rendered by this court to seek a petition for certiorari by a higher court.
So you're arguing that Mr. Dawson's sentence was not final for purposes of still being pending on appeal because we have case law that says if you're within the time to seek a writ of certiorari, then it's still pending on appeal and not final. Is that what you're arguing?
Yes, Your Honor, and that's exactly the analysis that's done in the 60-1507 case. Now, I know this isn't a 60-1507. This is a motion to modify, or motion to correct an illegal sentence. So that may require that it be viewed differently. However, I think that's a distinction without a difference. In both situations, the defendant is seeking relief from a sentence that he's claiming there's something wrong with it. I'm sorry, I'm losing my voice. There have been 5 briefs filed in this case. I filed the opening appellant's brief, the state filed their brief, I filed a reply brief, they filed a supplemental brief, and then I filed the petition for review. So I think all these issues have been fleshed out in the briefs. If there's any questions, I'll be happy to answer them. Otherwise,
Would some water assist you, counsel? I think there's water in the jug, and there should be some cups there.
that's better.
Oh, all right.
Thank you.
Does that conclude your presentation, or do you want to continue?
It does, Your Honor. I don't, unless there's questions by the court. I've tried to address the questions that I heard the court asking in earlier cases. I believe they're also covered in our briefs. I know specifically the question asked by Judge Johnson about the failure to include the retroactivity language is something that I specifically briefed.
All right. Any more questions? Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Assistant District Attorney Lance Gillette on behalf of the state. I want to try to address a number of issues here. First of all, we do believe that the defendant's sentence in this case was final before Apprendi was resolved. And to note that, and I acknowledge there was a different an argument that maybe he could have taken a petition for review, or a petition for cert, and I can't speak with absolute certainty to that today. But what I can tell you is that the 2 issues that he appealed in his direct appeal are not issues that are subject to cert. There were no constitutional questions in his in his 2 issues on direct appeal. He challenged the qualifications of an expert witness, and he challenged the sufficiency of the evidence, and he challenged the use of aggregated misdemeanors based on whether or not he had the right to count, whether or not they were canceled and the state had met its burden. So he challenged the sufficiency of the state's proof that his priors were counseled, not specifically that they were not. So I think that this defendant's sentence was final well before Apprendi. Again, this was a 1997 crime.
But he was affirmed on direct appeal in 99. When was the mandate issued, do you know offhand?
If you'll give me just a moment, the mandate issued March 24th of 2000, and again,
and Apprendi, I think, was June 26th, wasn't it?
That sounds correct, yes.
So that still wouldn't be within.
So I don't think he would even satisfy the 90 days. Just doing the math off the cuff here, which is not necessarily my strongest suit. It's why I'm a lawyer, not a mathematician or a doctor. So I want to turn to, I think, what is, I guess, the substantive question here, and it's because this is what the Court of Appeals decided the case on, is 223504 subsection 3, What is it and what does it do? Here, as has been discussed previously in arguments, the state does firmly believe that amendment, when it was passed, was a new law, and it was in direct response to Dickey. One of the cases and questions that Justice Steele you'd asked about before was the Lee case. I think I found the right Lee case, the Ammonia Lee at 304 Can 416. Shared that case with opposing counsel before we came in here. There, this court held that a claim that a term of punishment later declared unconstitutional does not satisfy the requirements for finding a sentence illegal. Extending from that, I guess we get into the realm of, I guess your question was, have we ever found a sentence, have we ever found an illegal sentence based on law that wasn't in place at the time? And I reiterate my response to your question earlier that yes, in Wettrich, I think that this court did. If I could, just to expand a little, I think that this court started inching that way with Dickey 1 and Dickey 2, and even before that with Neal. And I know we've talked about this at some length here, but 2235-04, in its former sense, began to be eroded with Neal, who raised a constitutional challenge, and this court allowed that to proceed because they found it resulted in a statutory error. Respectfully, 2235-04 should never have been the vehicle for such a constitutional claim. Defendants such as Neal, such as Dickey, and Mr. Dawson all had available to them at the time 601507 and 601501. And that is how they should have challenged and how this court should have required them to challenge a constitutional, a claim that their sentence was illegal due to some unconstitutional for an unconstitutional basis. There's nothing that would have prevented them from doing that then, and the only procedural bars stand in the way of even Mr. Dawson attempting to try to do so now, with although those are almost certainly preclusive at this point. So the addition of subsection 3, going back to the provision that is at issue here, that did a couple of things, as the Court of Appeals acknowledged in the opinion here. It in part defined an illegal sentence, and it also set a clear temporal limit. Previously, we'd only had the 3 types of claims that could constitute an illegal sentence. Notably, a constitutional claim is not part of that. And then it also added it as this temporal limit to make it clear, perhaps seeing writing on the wall, that should a change of law occur in the future, the legislature doesn't want us going back in time. And I think that is important, and it is appropriate to apply those provisions here.
Counsel, since you're pausing, I'm going to rewind to something you said earlier. I had to take a minute to pull Wettrich up. It looks to me like, correct me if I'm wrong, Wettrich was a direct appeal.
I think that's right. Yeah.
So then how does Wettrich fit the category that I had asked you the question about earlier of applying a new law after the sentence was final? If Wettrich was a direct appeal, his sentence was never final.
Well, his sentence, I suppose to a certain degree that's true, but his sentence was established and defined based on the law that applied at the time he was sentenced. And that was what we discussed earlier, the definition of comparable.
Right.
At the time it was pronounced. And had there not been a change to the definition of comparable, that's final. I mean...
It's not final until it's final on appeal. If somebody takes a direct appeal from their sentence isn't final until the direct appeal mandate comes down.
That is true, but there's also no basis for him to make a claim if it weren't for this changing the definition of comparable.
Always apply to cases still on direct appeal when they come down. The conventional rule, are you claiming some sort of an exception to the conventional rule? That
No.
A decision on appeal applies to anything that's still pending on direct appeal at the time?
No, what I'm saying is that what Wettrich did is that it reaffirms Moncla, And it says that, yes, it is a direct appeal. The problem is that it then changes a definition and allows it to apply.
Well, we can argue. You can argue about whether Wietrich was a change in the law, but what's not arguable is that Wietrich it wasn't on a motion to correct an illegal sentence. It's not an illegal sentence case. It's a direct appeal.
Well, but I think that he challenged his sentence as illegal as part
But he
of his
didn't
direct
follow the procedural mechanism of a motion to correct an illegal sentence.
Right.
And that's what we're talking about. We're talking about the motion to correct statute pre-2017 and post-2017 amendments. And
Right.
I'm just asking how can Wietrich have any applicability to construing that statute? Because it wasn't a motion to correct an illegal sentence.
To construing 223504 subsection 3. 223504 subsection 3.
period.
Yeah.
He's saying it wasn't a,
You can make an illegal sentence claim, but if it's in your direct appeal, then you're not bringing it as a motion to correct a legal sentence. You're just claiming you have a legal sentence as part of your direct appeal. Isn't that what you're saying?
And I understand. I think that's what you're saying. And I acknowledge that. But the illegal sentence statute at the time that was passed in 2017 and that should have been applicable to Wietrich, I believe, was that subsection 3 was already there. And if I'm mistaken on that, then so be it. But he should have been precluded from making this change in the law.
You think that the 2017 amendments to the motion to correct an illegal sentence actually pared back a defendant's appeal rights? Is that what you're saying? That it took away appellate issues from defendants on direct appeal?
That's what you're suggesting?
I just don't understand how that could be
That would
possible.
be truly revolutionary.
That
You really
would-
think
no,
that's
no.
in the legislative history?
What I'm saying is that this is a problem in that I'm not 100% certain on the timing, but I believe that at the time that Wittrick appealed, that subsection 3 was there.
So what? That's what we're saying.
Right.
The legislature can't just by fiat erase claims that defendants can bring on direct appeal, can they?
No, they cannot. But his claim was a constitutional claim that normally would have been precluded, and that would include
Only
applying
if brought as a motion to correct a legal sentence, not as part of his direct appeal. That's the problem here.
And then there became a change in law that was then applied to give him relief based on his constitutional claim. And while that may have been as part of his direct appeal, I still think that there has to be some construction of 223504 subsection 3. But to get back to this particular defendant, he is differently situated than Mr. Wettrick was. There is no doubt about that. I do want to speak briefly to, and that is because his case was final before Apprendi was decided. Mr. Wettrick was not. As for 223504 subsection 3 and its lack of retroactivity language, given the brief amount of time, that these cases have been argued over the last couple of days, it has been questioned a number of times about what about the changes to felony murder, the hard 50 are two examples that were given. I do want to point out that just in my limited research, those statutes are codified in Chapter 21. Those changes are all part of actual criminal sentencing statutes. So I think it's at least relevant for this court to consider that 223504 is part of the Code of Criminal Procedure. I don't think it was necessary for them to include a retroactive language because it is clearly codified as part of the Code of Criminal Procedure. Furthermore, the absence of retroactivity language certainly does not preclude retroactive application, as this court has found a number of times.
and the presence of it doesn't guarantee it either.
Not necessarily.
Yeah.
Let's, putting aside whether the first argument about whether the sentence was final, we have Dickey 1 in May of 15 and this motion in July of 15. 2015.
Can you repeat that? I'm gonna
Okay,
write.
Dickey 1
Yeah.
was May 22nd, 2015, and this, the motion to correct the legal sentence was in July of 2015, and after Dickey 1.
Right.
Okay, and then we have the amendment effective May 18th of 2017. And so we have the motion filed, and my question is, if the motion would have been successful based on Dickey 1, but for the statutory amendment a couple of years later, why isn't that substantive? Because he had the right to have a reduced sentence, and the statutory amendment basically increased his punishment that otherwise would have been applicable.
So I think this, if I'm understanding Your Honor's question correctly, what we're starting to talk about is vested right and whether or not.
Correct.
And my argument to that is, it would begin by pointing out that the defendant has never identified a vested right in this case. He's not specified any vested right that he was entitled to. And I would ask this court to investigate that, consider what vested right, or consider that issue that yourselves. What vested right are we talking about here? This defendant, he cannot have been entitled to a vested right of Dickey. Dickey was decided long after he was sentenced, and furthermore, it was also decided long after he had previously pursued relief based on claims of a legal sentence. He can't be claiming application of Wettrich because it's a different situation. I would pose to this court that the only potential vested right at issue here would be application of the prior version of 2235-04 that lacked that subsection 3. The problem that this defendant runs into is, even if this court finds he had a vested right to application of the old illegal sentence statute, he still is precluded from obtaining relief here based on Gould that says people that are done prior to Apprendi do not get Apprendi on collateral review.
I said put aside the finality, okay, as to whether the legislative amendment impacts a substantial right or vested right or whatever you want to call it, and to me a liberty interest. If but for that amendment, he would spend less time in prison, and that amendment means he spends more time in prison. I'm having a hard time saying that that's just procedural, no substantive effect. And when somebody's sitting in prison, that's kind of a substantive effect.
Well, I think that Your Honor's hypothetical might need a little bit further development and maybe even potentially additional briefing in a case that was sentenced after Apprendi. I can't set aside the fact that this case was sentenced before Apprendi, because this court has told us, and all of these constitutional issues, they have some kind of time limit to them. We don't simply go all the way back to the Constitution and start applying decisions retroactively. We generally apply them only prospectively. I hope that I've answered your question on that, but the bottom line is this defendant.
So you're saying that this has retroactive effect, the 35043, to all cases that were final before Apprendi.
Yes.
Is that what you're saying?
Yes.
But it doesn't have retroactive effect for anything that was not final before Apprendi.
It could, if a claim final after Apprendi was based on some other change in the law, if that makes sense. And I don't know what that case might be. I simply don't know.
Why would that be distinct? I'm confused. I thought that's where you were headed this morning, that really you're just focused on cases sentenced before Apprendi.
Right.
In terms of retroactive effect, but I don't get how you draw the distinction.
If a claim is based on Apprendi, I think we can all agree was a change in the law, and I think that drawing the line at Apprendi for the retroactive application of 3504 subsection 3 is absolutely appropriate.
But why wouldn't that be true of any constitutional claim that would make a sentence illegal? I mean, I just don't understand why Apprendi's so special, other than the fact that it happens to be the case in front of us.
Well,
Can you explain to me that?
Apprendi is special because the United States Supreme Court told us it's special.
No, I just don't understand why it would be different from any other constitutional claim that somebody would bring on a 3504.
Because Apprendi, in both federal law and here, it is not applied retroactively. So we can't go back to cases that are done prior to Apprendi.
Counsel, this gets to one of the questions I asked earlier about why do you even need the statute? You're not really describing a retroactivity problem. You're talking about what was the law at the time the sentence became final. And if it was pre-Apprendi, that's what the law was.
Right.
And it was a legal sentence, so how can you proceed under this motion? Is that where you're heading?
Yeah. Again, why do you need the statute? The 2017 amendments.
I think we needed the statute, and this goes a little far off field from this particular case, but I think we needed the statute to protect from future changes in law. We can't always anticipate always the next Apprendi, but what we can say is to clearly define, and this is following in the aftermath of Neal that has already chipped away at 3504. To say that, look, if things are going to be changed in the future, we need to draw a line. And that is both temporally and substantively, as the Court of Appeals found.
Is that what happened with the lien and the hard 50? Are you saying that this operated the same way? I mean, we had a lien come in and we had a whole bunch of people sitting in prison on hard 50 sentences, right? Who had ended up there because the judge said the
Right.
predicate facts are present.
Right.
And a lien comes in and says, nope, judge doesn't get to make that call. I mean, all of us thought prior to a lien that a mandatory minimum was different from an increase, but
Right.
apparently we were wrong. So we have a lien, and then
Well, a lien has not been construed as a change in the law by either the United States Supreme Court or necessarily this court.
so that's the answer to my previous question, is that so far nobody's asked the U.S. Supreme Court whether it was a watershed change or whatever.
If they have, I'm simply not aware of it for the purposes of this oral argument.
Okay. But in that case, the legislature went back and changed the hard 50 law
Right. And
and said, we think it's retroactive.
right, they added the retroactivity language, but again, that was within a specific a specific statute that was not part of the Code of Criminal Procedure. It was part of the Criminal Code. And I think that is a significant difference that merits consideration by this court.
It's a factor at least.
At least, at the very least. If I may have a few seconds just to wrap up, Your Honor.
Do we have any questions before he wraps up?
I just want to clarify that I'm understanding you, that you're arguing that 22-3504-3, that was effective May 18, 2017, only applies retroactively to those sentences that were final prior to June 26, 2000 filing of Apprendi.
If a claim is based on Apprendi, then I think that's where we have to draw the line. I can't foresee every possible or alternative situation where there may be a change of law claim that would require going back and looking at that decision that is potentially construed as a change in the law.
If you'd like to wrap up in 1 moment, I think you said?
Yes.
30 seconds worth?
That's plenty. I do appreciate this court's time and patience this week in addressing all of these issues. I think everyone's goal, hopefully, is to obtain a broad, clear statement of what we're trying to do with criminal sentences to make our lives easier and also the defense bar's lives easier, so that we can advise our clients and our victims in our cases. And we would simply ask that in this particular case, that the defendant's sentence be upheld.
Thank you, counsel.
Thank you.
Thank you both for your arguments this afternoon. Court will take this matter under advisement.